Hi, I'm Sathish Balasunderam. Today I'm going to talk to you about an Ontario family law concept called Equalization of net family property, which will be of interest to you if you are part of a former married couple who has decided to separate and divorce. It is part of an automatic property sharing regime in the province that applies only to married couples. If you're part of a common law relationship that has ended, this concept will not apply to you, although Canadian law may nonetheless assist you in some circumstances. If you are in this situation, be sure to seek legal advice as to your rights. The discussion starts with the concept of net family property, which is a term defined under the Ontario Family Law Act. In Ontario, the law recognizes marriage to be an equal partnership and each spouse's contribution is given equal weight. The law in this area operates using two basic principles. One, the value of any property that either spouse earned, obtained, or acquired during the marriage and which still exists at separation must be divided equally. Two, during the marriage, any increase in the value of the property that a spouse owned at the date of marriage must also be shared. In simpler terms, each of you as former spouses must calculate the value of your property on the date of separation minus any debts and subtract the value of his or her property minus any debts on the date of marriage. The calculation of each spouse's share results in what is known as their net family property. When each of you has calculated your separate net family property values, then the next step is to compare the values. More often than not, the two values will be unequal. This is where the equalization part of the exercise comes in. Not surprisingly, it involves a straightforward transfer. The spouse with a higher net family property will usually owe the lower net family property spouse a payment, known as an equalization payment. The overall result is an equalization of net family property. The legislation does carve out some exceptions to the general rules governing the calculation of you and your former spouse's net family property, or NFP. Under the province's Family Law Act, there are certain property that can be excluded from the calculation of each party's NFP. The main exclusion is your matrimonial home. This is the home you and your former spouse lived in together immediately before separating. No matter which of you owned the home at the date of marriage, its value on the date of separation is not included in the calculation of either spouse's NFP. In some unusual circumstances, a cottage may also be considered part of the matrimonial home and likewise excluded from the NFP. But this will depend on the nature and extent to which you, your spouse, and children used it during the marriage. Under this matrimonial home exception set out in the Family Law Act, the total value of the matrimonial home is excluded from the NFP calculation, not merely any increase in value during the marriage. Other exclusions are set out in the legislation. For example, a spouse's NFP excludes gifts or inheritances that he or she received from someone else during the marriage. However, even this exception comes with an important stipulation. The money or inheritance received this way cannot have been used towards the purchase of a matrimonial home, because in that case, the exemption is lost. With a divorce looming on the horizon, you will have many questions about the process and many concerns about how the financial affairs between you and your spouse will be handled. The law in this area is very complex, and it's important to seek legal advice. Please feel free to contact me for a consultation.